I'm joined today by Colin Passmore, who needs no introduction, and we're obviously going to be talking about privilege. In-house privilege is something which has been a big issue for me during my career and has been a real source of discussion at a lot of the in-house meetings that I go to. How to maintain it, what are the best practices, and then what are the risks? So obviously disclosure risk, but where you have US businesses, there's also a risk of being subpoenaed and no one wants to see their in-house counsel in court. So today we're going to talk through the different types of privilege and the different steps that in-house counsel can practically take to maintain privilege during this podcast. So first question, Colin, is advice that in-house counsel give to their businesses privileged?
Well, thank you for that, and thank you very much for the kind introduction. The starting point is that under English law, in-house lawyers, in-house counsel are in exactly the same position as your external advisors. So whenever you give legal advice, whether it's on interpretation of a statute, a statutory instrument, on a contract, whether you're drafting a contract, whether you're giving legal advice on merits of an investigation or litigation, the simple test I use is if it would be privileged as with an external counsel, then it's going to be privileged for you. Now, there are obviously some caveats here. The first one is that very often in-house lawyers don't just give advice on legal issues. They will get dragged into some of the commercial issues, and indeed it's not unknown. I've certainly seen examples of where lawyers have actually been the deal makers, the deal negotiators. As a lawyer, no matter if you're employed as a lawyer, if you get sucked into the deal making side or you're giving commercial advice, or even if you're the company's secretary giving secretarial advice, that is not privileged. I think the second point to remind everyone of is in-house, you must be employed as a lawyer. So you should be a member of the legal department. If you are a lawyer, but you're in the deal-making team, the M&A team, so you're not employed as a lawyer, then the advice you give will not be privileged, because you have to be a lawyer or employed as a lawyer when giving that advice. It also follows that just as with external law firms, if you've got secondees, if you've got Australian, New Zealand qualified lawyers, for example, in your team, you've got trainees. If they're working under the supervision of the lawyers, their advice will also be privileged. I think the third thing you have to bear in mind, just as we do with external counsel, is when we're talking about legal advice privilege, you have to bear in mind Three Rivers number 5. This is what I call the wretched Three Rivers number 5, where in the context of advising a large organization, a company, usually, you have to be able to identify those people who are regarded as the privileged client, i.e. those whose job it is to give you instructions and to get your advice. Now, the problem with this in an in-house context is that very often you're asked to give advice out of the blue very fast. I just need a quick piece of advice. Can I pick your brain? What's the answer to this? You cannot internally say, whoa, stop, who's my client? Because the whole business would break down. Where this is important, though, is if you have a large investigation, if you spot a large problem, which you know needs to be looked at, even if you have a large M&A deal. I think a lot of businesses make the mistake that 50 people will be involved in the negotiations, going back and forth to the lawyer. Who is your client? You have to try in those circumstances, as much as it will irritate the business, to say, I do need to work out some basic parameters around privilege. But as I say, you can't do that for everything you do. You can't have the privileged tail wagging the business dog. So think about the big matters. You know, you've been selling a product, you get wind that there may be some problems with it. Doesn't mean to say there's litigation, but you know you've got to go and investigate it. That's where you need to know who your client is. And that's when you need to, as importantly, identify who is not your client, because those are the people who tend to say, oh my goodness, this is a problem. And thereby they've created unprivileged, potentially disclosable material. So I think the three things are, normally, all your advice is going to be privileged, so long as it's legal advice. Commercial advice, no. Make sure you are employed, engaged as a lawyer within the business. And then finally, just keep Three Rivers in mind for those bigger occasions.
Thanks, Colin. Just a couple of questions out of that. So employed as a lawyer, does that mean you need a practicing certificate?
The reality of our practicing certificate regime is that every lawyer must have a practicing certificate, unless, and there is this amazing exception, unless you're employed within government. And the only reason I know of for that exception is to save the government money. But you must have a practicing certificate. So there's a bit of a myth that if you're in-house and you're a tax advisor, you don't need a practicing certificate. I don't know where that comes from. Everyone should have a practicing certificate who is qualified as a lawyer. But thereby, because you have a practicing certificate, doesn't mean to say everything you do is going to be covered by privilege. So you've got to remember the 3 rules that I've already outlined.
And how about employed barristers?
As long as they are employed as lawyers within the legal department, subject to your or another senior person's supervision, no issue.
And now thinking about the type of advice that in-house counsel have to give. So thinking about multi-jurisdictional organisation, and some of that advice may be given to companies outside the UK. So I'm an English qualified lawyer, and I was advising on US patents to our US subsidiaries. So not squarely English subject matter. How does privilege apply in that context?
English law of privilege, it can only be asserted in an English court. So the fact you are giving English privilege advice to a US entity, let's suppose that entity gets into litigation in California, New York, Washington, it'll be almost certainly the local rules of privilege that will apply. Now, there are a number of jurisdictions where the rules differ to England. So, for example, if any of your listeners have subsidiaries or head offices in Australia, Australia is much more focused on whether in-house lawyers are actually giving legal advice. So you would need to get Australian law advice on the current position there, because you can't assume that what is privileged here will be privileged there. It's quite extraordinary. I've seen, because I'm sad enough to look at the case law, many attacks on in-house lawyer privilege in Australia. It virtually never happens in England. So the court's opponents treat our privilege as with considerable respect. The other jurisdiction you must always keep in mind is states in the US, particularly if you're doing a cross-border transaction, because what is privileged here won't be privileged there. And so, for example, you can waive privilege quite happily under English law. It could have devastating consequences in New York. So again, on the big matters, you really need to get your teams, your external advisors, to work out what are the privilege rules right at the outset. No good doing it when a problem arises. So I think in summary, the watchword is, by all means, and I think we're going to come on to this, you can share privileged material with subsidiaries. We'll come on to talk about that. But you've got to be aware that some jurisdictions just simply have different rules.
Looking in the context of a larger transaction, and we were talking about different types of communication and legal advice and commercial advice, and perhaps having to look at mitigating the risk that those kinds of mixed communications, which are often email, maybe some attachments, are going to happen in that kind of context. So my question is, what is the kind of way to safeguard privilege in that situation, and what are the things that in-house counsel can really think about in assessing where they need to take extra steps? Because obviously we talked about the issues with privilege and the privilege tail wagging the dog. How can in-house counsel sort of avoid that?
I think the first point is that counsel must work out how important is privilege to their business. Now, my experience is that the vast majority of businesses actually take privilege quite seriously, and therefore, within reason, this is the privilege tail point, will be amenable to taking steps to looking after the privilege. And I think, therefore, that the more senior people, the more senior lawyers in each organization should be ready to have a conversation at the outset of a big matter with the commercial counterparts to just warn them about the importance of taking often some quite simple steps to protect privilege. Now, as I said earlier, where you've got a cross-border matter, whether that's the UK, the US, whether that's the UK, Asia, because bear in mind, for example, Three Rivers Number 5 isn't followed in Hong Kong or Australia. So they can create what in their eyes is privileged material under our rules. If only legal advice privilege is available, it's not privileged here. So you have to have those conversations at the outset. But then in terms of the business, I think what you've got to get across is, first of all, not everybody can communicate with the benefit of privilege with the lawyers. So you come back to this point, who is the client? Who is the privileged client? And if people, if senior business people don't quite get that, to my mind, the best example is there are many people in this transaction, whether it's an M&A transaction, whether it's trying to find out what was the genesis of this product, why has it gone wrong, how was it developed, how was it tested. There are many people who will communicate without the benefit of privilege because they're outside the scope of the client. Those people will be creating potentially disclosable material. And so you've got to identify who can, who can't. And with the can'ts, they have got to be careful what, if anything, they put into writing. And we've all seen it. This product is rubbish. I can't believe we put this on the market. Who on earth approved this? They need their head seeing to. Who hasn't seen emails? And it's so easy on email. People don't think enough about what they're writing. So that is very, very important. We then come to my favorite paragraph in my favorite Court of Appeal case, which I think all in-house lawyers should read. Just this paragraph, if you don't have time to read the judgment. The judgment is from 2020-2021. It's called Jet 2, and it's paragraph 100, where Lord Justice Hickinbottom sets out guidance on the do's and don'ts of internal email chains. And this is the bit that I think causes the problems. What this paragraph makes clear is that if you mix lawyers with their privileged clients and with other people in the business, all on the same chain, and you know what happens, you get an email pile on. Everyone needs to justify their existence and have their say. So everyone answers. Not every answer is going to be privileged. So the lawyers, I think, have to be really disciplined. This is a request for instructions. This is my advice based on those instructions. These are the people it needs to go to. If the business come back and say, well, actually, we need a commercial decision here, everyone must realize, should that be on a separate email chain? Not always feasible, I accept. But in any event, that will not become privileged just because the poor in-house lawyer has been copied in. And when you get into a dispute, as sometimes you will later on, a whole bunch of paralegals, AI machinery, I suppose these days, is going to have to go through thousands of emails. Which one is privileged, which one isn't? And someone, probably a senior in-house lawyer, is going to have to do a witness statement to say, statement of truth, this is privileged, this isn't. So you've got to really think about these email chains. Same with WhatsApp, same with all other quick, fast electronic mediums for communication. You've got to try and be disciplined. We don't need everyone on this email chain, just as we don't need everyone on this call. And it's not easy because the business will say, sorry, I haven't got time for this. We've got to get on with it. We've got to get on with it. We've all been there. But those are the things that you've got to think about.
Thanks, Colin. I think thinking about sort of advice and the group now. So coming on to the subsidiary question. So I'm employed by one group company, but I'm providing advice to another group company. So they're not my employer, but they're within the group. Does that impact who is the client for the purposes of the advice? And what steps can I take to make sure that I've protected myself adequately?
Right. I think there's three issues here. Ideally, here's yet another counsel of perfection. I know people listening to this will now be tearing their hair out. It doesn't happen like this in practice. I know it doesn't, but this is just something to think about. It would be fantastic if every employment contract said, you are employed to give advice to X PLC and all of its subsidiaries all over the world. Okay, so maybe the HR lawyers listening to this can have a think about that. The second thing is you've got to distinguish between giving advice to a subsidiary and sharing advice with a subsidiary. And the two are very different. Three Rivers will apply to the first situation. It does not apply to the second situation. I'll come to that separately. Now, I've always taken the view, and there is an Australian case, I think it's called Seven Networks. If anyone is really interested, it is discussed in chapter 4 of my book, which incidentally will be updated next year, which recognizes that an in-house lawyer in a multi-subsidiary entity can give legal advice. So long as it's legal advice, it's confidential, it's your job, it is you as a lawyer to people in those subsidiary organizations. The usual rules about Three Rivers will apply from an English law perspective. So you've got to keep that in mind. The more normal position is that you have given legal advice to your board, for the head office, to the holding company, the main company, and very often the question is, well, can we share it with the subsidiaries? And that has got nothing to do with Three Rivers, because that is the point at which the advice is given, it's finalized, and the board thinks it's so good we should make sure everyone sees this. And the view I take of that, and I have not seen a single case in the common law world, I do not include the US in that because I don't study US law, but Canada, Australia, New Zealand, Hong Kong, Singapore, England, Ireland, Channel Islands will treat that as the sharing of privileged information. And under English law, but not US law, I'll come back to that. Under English law, sharing that information on a confidential basis with a subsidiary company is going to be absolutely fine as a matter of English law. Now, share it with a US subsidiary, I don't know what the answer is. So you would have to stop and think what is going to happen in the US, because I have seen situations where a perfectly acceptable, legitimate waiver under English law has all sorts of horrific consequences in America. But as a matter of English law, and as I say, most common law countries, New Zealand, Australia, Canada, they're going to be absolutely fine with that. So if you've got any doubt about, is there a country out there, I mean, for example, China, PRC, does not recognize privilege. So if you share it with a PRC subsidiary, and I think, but I can't swear to this, that South Korea is the same. Stop and think, should they see it? Should it be on their service?
Great advice. How about if you have taken external advice? How do you mitigate the sharing risk there? Is it that we need to ensure that each subsidiary is also a client of the firm so that they are directly receiving the advice along with you? What's the best practice in that situation?
Well, I think the starting point is it should be exactly the same as with the in-house lawyer's own advice. So the subsidiary does not need to be a client. So if you, as general counsel, have obtained that advice from your lawyers in London, you can do this confidential sharing with the subsidiary. And English law, as I've indicated, is very, very generous in this respect. The question mark would be those jurisdictions like PRC, South Korea, possibly, and the US. What are the consequences of sharing it with a subsidiary in those countries? Now, I'm not saying in the US that you can't do it. I'm just saying I didn't know the rules. And every time I check the rules, I know sometimes there can be some challenges. But generally speaking, it is perfectly legitimate to share privileged information on a confidential basis with subsidiaries within the same corporate group.
We've talked about sort of legal advice privilege, but moving into litigation privilege, when would that kick in? So, for example, I have an internal investigation. If the result of the investigation is such, it may lead to litigation. So there may be contemplated litigation, but we don't actually know at the start when we're starting to provide advice. When does litigation privilege kick in, and how much more broad could that be than purely legal advice privilege?
Well, let's deal with that last point first. If litigation privilege is available, Three Rivers goes out of the window, and therefore you can communicate with anybody in the entity, within the subsidiaries, as a matter of English law, so long as those communications are made for the dominant purpose of the contemplated litigation. And by the way, you've just reminded me, I should have said, of course, dominant purpose applies to legal advice privilege these days. Right, the problem or the challenge with an internal investigation is it can well start on a non-adversarial basis, so that litigation privilege doesn't apply. But it is possible that during the course of it becomes apparent that it is adversarial, at which point litigation privilege can kick in. Now, it is a real art skill to identify that precise tipping point, and there's no easy answer to this. You have to be at the point where you can say, from then on, it was apparent that litigation was reasonably in contemplation because we had discovered these facts that indicated that there was likely to be a claim. And it's very easy to state that as a principle. It is difficult to put that into practice and identify that tipping point in a particular case. So there are instances in the case law, and I think one of the PAG RBS decisions about 6-7 years ago had this precise point. A regulator wanted information out of the bank, but they made it clear that they were engaged in a fact-finding exercise only. So it became virtually impossible to say, well, we were pretty sure litigation would follow out of this, and the court held, well, no. They made it clear they were only after facts, and they needed those facts to have that later deliberation, is there something here we should investigate? There was another case a couple of years ago where this exact problem arose. A Luxembourg bank, I think it was called State of Qatar against Haviland. And it was a first instance decision, maybe 3 or 4 years ago, where a regulated entity realized something had happened and knew they needed to make a report to their regulator. They engaged accountants to come in and help investigate what had happened. And the terms of engagement of the accountants made it clear that they were there to investigate what had gone wrong. It was only later, about 6 weeks later, that the bank realized that having made reports to the regulator, having got the accountants up and running, there was likely to be litigation. And the whole issue there was, at what point did litigation privilege kick in? And the consequence of this was that the majority of the work of the accountants was unprivileged. And that was because no one thought about this at the outset. So what exactly was the accountant's role? But also, were we in a position where we could say litigation or regulatory consequences were in contemplation, such that litigation privilege kicked in? And that, again, was a very difficult one. And there were various competing events as to when litigation would kick in. And the judge found that it kicked in at quite a late stage. And he made the point, I think actually he rather nicely quoted from my book, that it's quite difficult to identify this tipping point where you go from non-adversarial, i.e. Three Rivers legal advice privilege, to adversarial, where Three Rivers falls away, and litigation privilege with its much wider scope kicks in. And had litigation privilege been available, it was quite possible that the accountant's work would have fallen within the scope of litigation privilege. In this case, it didn't.
So you talked about the tipping point between moving between legal advice privilege and litigation privilege. Can in-house counsel help with identifying when that is? So if you're responsible for an investigation and some facts are uncovered, which you think means that litigation could be reasonably contemplated, could you sort of put a stake in the ground by sending an email to the people you've identified as your kind of client team to say, we found these facts and now there's a litigation risk, and so litigation privilege will now apply, so that at least there's something you can point to when that assessment's made later, or if that assessment's made later?
I think that is precisely what a top litigator, in-house or external, should be willing to do. After all, if the matter goes to court, that's what the judge is going to have to decide. So why can't you have a go? You're there in the thick of it, and you should be doing exactly that. Of course, it's a brave decision in the sense that you're setting yourself up to be knocked down, and you're going to be attacked. But what I often say is, you should prepare a note of all the reasons why at that point you thought litigation privilege was in contemplation, such that the privilege kicks in, and you should be ready to disclose that note. There is a waiver issue there, but of course waiver is limited to what we call the single transaction, which in this case would be the note you wrote as the in-house lawyer on why you thought litigation privilege kicked in at that point. If there are 100 emails amongst a small team, including external advisors, as well, do we think we've reached the point where litigation privilege has kicked in? Those could arguably be disclosable if you use this note at a later stage, if you get challenged. You did it 4 weeks too early. But I would always say, make that note and be ready to disclose it. Shut down as far as possible all other communications around this point, because you then limit the amount of potential additional disclosure. But I think litigation should be ready to do it.
Great. That makes sense. So I think moving on to the last question and thinking about, in the context of litigation, disclosure more broadly. So I have a lot of US matters and they are very keen on a common interest agreement. So Deminor's a litigation funder. We want to see opinions from law firms around the cases that we are reviewing as part of the due diligence, and US counsel are very keen on a common interest agreement to help to preserve privilege for some of the things that they're disclosing to us. In England and Wales, what's the kind of risk with disclosing to third parties in the context of litigation? So obviously counsel and outside advisors are part of the legal team, but if it's an accountant or a funder, what's the risk around that, and how can in-house counsel mitigate that here?
Well, look, I think the first thing to say is auditors do not have a statutory right to see privileged information belonging to the company. I think that gets overlooked, and that's why I think, amongst other things, the FRC tried to get some provisions in some new company legislation overturning the Jet 2 decision, which touched on that from a regulatory perspective. Of course, as a practical matter, the auditors may well say, well, if you don't show us this, we can't sign the audit off. What I've seen of late, because of the concerns that if auditors get hold of this material, the auditors can be summoned to produce that document, perhaps by a regulator, perhaps by an opponent in litigation with you, or it might give rise to some sort of waiver. Now, US lawyers, I think, are very hot on common interest privilege agreements. In my view, they've got out of hand. I think I saw a 50-page one a year ago. I just don't think you need to go into that level of detail, but US lawyers, I'm sure, will have their own reasons for doing this. What I've seen and what I've helped draft in England is taking a different, but in my view, a much better approach. I would say that because I think I'm never convinced of the utility of common interest privilege, because there is a much better way under English law. You're allowed to share privileged material with a third party, not an opponent, by the way, not an adversary. You can actually share it with a regulator on a limited waiver basis, albeit that gives rise to a whole different series of challenges and potential problems. But in terms of sharing it with an auditor, you can do a very simple, and I mean simple, 2, 3, 4-page agreement that spells out you are going to show the auditor your privileged advice from yourself or from your external advisors. You are sharing this on the basis that the auditors will treat it as privileged, treat it as confidential. If you can get them to agree that only a handful of people within the auditor's business will see it, will look at it, so you can't let them pass it around the entirety of the business, not that they would. They will not quote from it. They will not use it in their public documents. They put it in the audit report. I mean, that's, that would just be insane. And they will also let you know immediately, if you can get them to agree to this, in the event someone comes to them and says, we believe you've got the Simmons and Simmons advice, can we have it? And they must tell you immediately, so that if necessary, you can go and get injunctive relief to stop this happening. Now, this is a uniquely English law solution. I think it would work in Hong Kong. I think it would work in New Zealand. It probably doesn't work in Australia. They don't like the sharing rules. And I'm pretty sure it doesn't work in America. And, whether you've got a problem thereby in America as well, depending on what litigation you're funding, where it is based. But as a matter of English law, that is a perfectly acceptable solution. And again, if you've got a US angle, go and get the US angle covered off. What are the consequences? You can do a common interest privilege agreement, of course, under English law. I just never quite see the point when you can share privilege, because our courts have been so generous about the basis upon which you can share. And so therefore, as between client and funded client and funder, again, sharing advice as between those two entities on confidential and privileged terms, perfectly acceptable. And an English court would be hostile to an attack to get that information out of you simply because you've shared it.
Thanks, Colin. I think the auditor advice is very helpful. I think I was maybe a little bit less kind to auditors when I had to meet with them each year, and I would show them the document, but I wouldn't provide them a copy. So
that's a perfectly legitimate tactic. I know a lot of audit firms hate that. Yep. And you've got someone in the room trying to scribble a note, but you have to. I think the one point I hope there's come out of this, well, two things. One is I'm a complete and utter privileged nerd, but leave that aside. Privilege is so unique and so beneficial and so sacrosanct. You have to treat it like a precious Ming vase. Okay, so you can't mess around with it. And that's what entities that don't have the benefit of the privilege in the way that the clients of lawyers do sometimes fail to understand. It also explains why the accounting profession tried about 10 years ago in the Supreme Court, I acted for them to get within the privilege, but we lost 5-2. It's a very, very, very precious thing. And so you have to look after it.
Absolutely. And I think dealing with sort of counterparts in subsidiaries in continental Europe, so maybe the European Council, where privilege doesn't have the same status and doesn't have the same impact because there's no real disclosure. It's quite difficult to explain, why that's so important here and elsewhere and in other common law jurisdictions. Just to pick up on one point that you made, sharing with a regulator and the problems around that, would you be able to kind of expand on that and give some tips for in-house counsel?
There is nothing in principle to stop you having a limited waiver arrangement with a regulator, whether that's the SFO, the police, the FCA, the FRC, doesn't matter who it is. The difficulty is that there is not a single regulator that will give you a cast iron assurance that there are no circumstances in which they would have to use that privileged information against your own interests. So the FCA, for example, I think somewhere in its guidance, I don't have it right to hand, expressly says you can give this to us on a limited waiver basis, and so far as possible, we will try to respect that. But we cannot inhibit our statutory functions. And so if we need to use this, we will use it. So, for example, if you give something to the FCA, and again, there's another RBS case where this happened, and the limited waiver was attacked by RBS's opponents. The waiver was upheld because up to that point, the FCA had held on to these documents and kept them confidential. The fact that the SEC could have come to the FCA and said, gateway sharing powers, can we see this, was neither here nor there because it hadn't actually happened. Had it happened, it could have gone across and then you lose your privilege. Similarly with the criminal justice authorities, they will accept privileged information up to a certain point. But if that information is relevant to a criminal trial, the criminal trial disclosure obligations will trump your privilege. And the SFO will always make it clear, and even if they don't, they will always act on the basis that the defendant's rights to a fair trial override your privilege. So you have to be very mindful that if you are going to give privileged information to a regulator, particularly criminal justice authorities, you are going to lose control. And they will not give you, they won't even contemplate giving you the same assurances as you can extract from the audit firm. So it's doable, and there are times when it's necessary, but it's really dangerous.
Fabulous. Thanks very much, Colin. That was a proper whistle-stop tour across all privilege, and I think it's given some really good tips for in-house counsel as to how they can really manage and mitigate the corporate risk, but their own personal risk in sharing and advising within business.